Good evening. Welcome to Dial a Lawyer. This is the fifth in a series of programs in which distinguished members of the Missoula Bar have offered their services free of charge to the public and are offering to respond briefly to questions that you may have. We have this evening three more of the members of the Missoula Bar who have, again, graciously volunteered their time. We have, to my immediate right, C.J. Tornabene of the Missoula firm of Patterson, Marcello, Tornabene, Schuyler, and McKenna. And to his right, Judy Wang, who is a deputy city attorney in Missoula. And lastly, we have Mark Connell of the firm of Connell and Beers. And briefly, to talk about the purposes of this program, we're encouraging your calls. Anyone can call, and the advice is free. You just call 542-6228, and we'll be responding to your calls over the air. The purposes of the Dial a Lawyer program are to, of course, be helpful, we hope, to the callers, and maybe educational to the general public at the same time. And maybe we'll even be a little bit entertaining. I see we have our first call already in, so we'll issue a quick disclaimer that we do not guarantee the accuracy of any advice that we give. It's not going to be the full-blown advice you'd ordinarily get after an initial consultation and full research into the facts and law. Is line one ready, or did we lose it? Looks like we may have lost a call that had been coming in. I started to say that your calls are taken free of charge, of course, and we don't really pretend to give you the full kind of legal advice that you'd have in the course of a normal lawyer-client relationship. What we hope to do this evening is just, as a public service, give some general guidelines and some little helpful hints that may be useful to people who are not sure whether they even need a lawyer or not. Do we have that call ready on line one? 1 minute. It takes a second for your call to be processed through the individual who's screening your calls. Line one's ready? Line one, you're on the air.
Hi.
Hi.
Yes, I was just wondering what I should do if I get in a car accident and the person doesn't have insurance and I'm injured.
Okay. Who wants to grab that one? Mark, is that your bailiwick?
Sure, I'd be happy to respond, Jim. When you're first injured, I think you have to be aware that you have responsibilities under state law to make sure that the accident is properly reported and investigated by law enforcement. And so generally speaking, you have an obligation to remain at the scene unless you're being transported for treatment of your injuries. If a law enforcement officer arrives, you should, if you can, keep the vehicle stationary at the scene. If it's blocking traffic or is a danger to someone else, you should move it to the side, of course. But generally, when law enforcement arrives at the scene, what you want to do is to answer questions, be cooperative, and then begin to consider where the situation leaves you as far as your civil rights are concerned. If you're injured, probably the best advice that we lawyers can give you is you should seek whatever medical attention is appropriate. And I always tell clients, irrespective of whatever legal claim you might have. The first concern is to get better and get better as quickly as you can. At the same time, you have to realize that you're becoming involved possibly in the civil litigation system. And when you have a situation like this, you want to minimize the contacts you have with the insurance carrier for the other side. You may or may not want to be willing to give a statement to the other person's insurance carrier.
Yeah, I'm wondering, excuse me, but I'm wondering if the other person doesn't have insurance.
Okay. You may have a claim under your own uninsured or underinsured motorist coverage. If you have insurance yourself, you may well have paid for that sort of coverage, and you may have a claim.
Okay, thank you.
Sure.
We have a call on line two. We'll take that call. Line two, you're on the air.
Yes, I was wondering if you could tell me about libel laws concerning broadcasting on, say, MCAT.
Gee whiz. Somebody want to try and tackle that one?
I don't think I want to try that one.
Not you. What about you, CJ?
That's a tough one. Let's talk about just general libel principles. There are basically two things you can cause yourself grief on. One is slander and one is defamation. Defamation is generally where you have written something that is causes problems for someone else. And slander is where you've said something that perhaps you shouldn't have. Cases like that are very difficult to prosecute, primarily because you have to show damages in a lawsuit, and damages from written word or from someone saying something to you are obviously going to be difficult to show, but in some cases they can be. A good example would be if you're a movie star and the National Enquirer has come up and said something that they shouldn't have. In that kind of a situation, I would think that a claim where it's going to affect your income or your reputation as an actor or actress would perhaps be meritorious.
All right. Thanks a lot, Chuck.
Where that call was from. Well, again, the number to call with your calls, which will be taken, of course, free of charge. No one's running up to your toll bill tonight, is 542-6228. Obviously, a show like this, we're going to be responding to what we call human interest legal problems, and we don't make any effort whatever at tackling more complex business litigation or tax, antitrust, or similar issues. We would say this, that some people on an occasion are not sure whether they have an issue that's really a legal issue or not. And if you're not sure, you can still feel free to give us a call. And I think many of the people who are on these panels would try to make an appropriate referral to an appropriate public service or other philanthropic agency that might be the place that your problem could be handled. And in fact, if we can't handle the problem and somebody in the audience who's a professional in a given area that thinks that they know where this problem could be better handled, we would appreciate calls that would comment on our advice to individuals. So if other professionals or even other attorneys want to comment, that's what the idea of the program is to have an open-air forum and try and help people solve their problems. Again, the number is 542-6228. We'll encourage you, and in fact, our person who's screening the calls this evening, whose name is Linda Marr, who also happens to be my secretary, will be ruthlessly urging you to keep the names of any potential people you're thinking of suing anonymous. We've never had any problem, it seems to me, with that on our prior 5 shows, but just we'll mention that briefly in passing. While we've got a quiet spot here in the show, I wonder if we could talk a little bit about what are some of the common questions that we get maybe in our practices that are frequently coming up that maybe would be of use to the audience. And I think before the show began, we mentioned in particular that we frequently get calls from people who are considering filing bankruptcy. I wonder, somebody want to try and tackle that general topic?
Well, I do a fair amount of work in bankruptcy. Just as a general subject, I guess perhaps it would be a good idea to talk about why people go bankrupt and why we have a society that allows it, because a lot of people get quite upset when someone does file bankruptcy. If you'll think back to your history, most of our laws come from merry old England, and if you didn't pay your bills in merry old England, they put you in debtor's prison and threw the key away. Not a real good idea, because as the years go by, you are unable to become a good tax-paying citizen. Your children are going hungry and things of this nature. Sometime in the 1800s, we came up with the concept of bankruptcy, and the idea is to give people a fresh start. Anyone can fall on hard times, and it's a good idea, as far as our society is concerned, to allow people to have a fresh start. That fresh start generally means that we wash away their debts, with some exceptions, and we allow them to start their life again with a clean slate. In each state, we have a certain number of, we call it exemptions, items that you can keep to get started, and hopefully that puts a person back on the right track again and they're able to go on with their lives. The damage of the bankruptcy is spread among society, which in this case means the creditors. And of course, no one likes to lose their money because of a bankruptcy, but nevertheless, that's how the system operates. I've represented people as debtors in bankruptcy, as creditors in bankruptcy, and even as a trustee in bankruptcy. And having seen the system in operation, I would say that it's a workable situation. It's an unfortunate thing that people get involved in, but on the whole, I can't think of anything better that would give people a fresh start and not hurt everyone in the community or any one individual in the community because of someone else's plight.
CJ, I wonder if I can ask a specific question based on the kind of calls that I frequently get. I see a lot of individuals who are thinking of filing bankruptcy who maybe shouldn't necessarily need to file bankruptcy, either because the kind of debts that they have are going to be non-dischargeable anyway, for instance, coming out of criminal cases or student loans or taxes, or they're basically judgment proof. In other words, they have no house they own, they have no large stocks, bonds, or fancy automobiles. They basically are not going to be in a situation where the creditor is going to hire an attorney and secure a judgment against them. Can you talk about where that line is and whether people, should worry about filing bankruptcy in that kind of situation?
Okay, well, there's, in each individual case, I think a person should consult an attorney and talk about the various options.
Do most attorneys charge an initial consultation fee for a bankruptcy?
No, particularly in the bankruptcy area, I think most every attorney will talk with someone first to see if there is something that can be done for them. Mm-hmm. And then after that decision is made, then perhaps they talk about the fees. The situation in bankruptcy is there are several different kinds of bankruptcies too, and one of them is not really a bankruptcy, and that's called a Chapter 13 wage earners plan. It may be that a person is not in such a position that they should file bankruptcy, but they do have problems, and perhaps a plan could be put together to slowly pay off most of their debts and put them back on their feet again. Mm-hmm. Also, there's a chapter that allows for corporations or businesses to reorganize, and once again, not really a bankruptcy, but more of a plan to get back on their feet. People that are facing, for instance, only a student loan may feel that they have a chance in bankruptcy also, even though bankruptcy does not normally allow for a student loan to be discharged or thrown out. If the individual can show enough hardship, then perhaps it will be thrown out. So, and when I say hardship, let's say that you've graduated from veterinarian school and you're the sole support of your mother who's an invalid and your grandfather who's an invalid, and 6 of your kids have medical problems. Perhaps the court would look at that after enough evidence was put forward and say this student loan is just too much of a burden, and we're going to let that one go too. So sometimes those things are not necessarily non-dischargeable. Mm-hmm. There are people that have nothing, they have debts against them, and there's nothing the creditor could ever do to get any money from them. Obviously, those people need not worry about bankruptcy unless they would just like to stop the general harassment that creditors might perpetrate on them, because the creditors don't necessarily know that, and they continue to go after the person looking for their money. When you file bankruptcy, you are protected from harassment by creditors, and so that's one of the benefits that the person gets when they start their new life.
Jim, I might add a question that we often field. relates to people who feel they've been wronged by someone else's intentional act, or fraudulent act, or malicious act, and they are faced with someone who's done whatever has been done, and they are concerned because the person doesn't, or the person is maybe making a threat to file bankruptcy. And the bankruptcy laws, and I know CJ is well aware of this, the bankruptcy laws generally provide that some relief for people from honest debts. But if there is a situation where someone has intentionally harmed someone else, a punch in the face, you often run into this kind of situation, some other intentional injury, or a fraudulent act, or one that generally the law presumes is malicious. And in those situations, the law will sometimes accept from bankruptcy any debts that arise from that type of behavior.
Let me ask one more question while we're on the subject of bankruptcy that comes to mind. I take it you're aware there's a federal law that people can just tell creditors, I've had enough correspondence with you and I'd rather not hear from you anymore, something to that effect. And to what extent is that efficacious?
Well, I think you're talking about the Fair Debt Collection Practices Act. And under that act, essentially, a creditor has certain procedures that he's allowed to follow to collect a debt. And at some point, the person that he's trying to get the money from can say, I've had enough. I don't want to hear from you anymore. And the choice is either talk to my attorney or just do not correspond with me any further. That is a signal to the creditor that his only recourse now is to file a lawsuit. He either stops the matter entirely or files a lawsuit and takes it to a court of law. That may precipitate a bankruptcy, obviously. It's something that a lot of people don't quite realize, that even if a person has a judgment against them by a creditor, they can still file bankruptcy and they can wipe out that judgment. That judgment is no good in bankruptcy court, even though it was obtained in a proper court of law prior to the bankruptcy.
Okay, well, thank you, CJ, and we'll take any calls. They're kind of slow, it seems like, tonight. I don't know what we had on before us here, but it seems like it's a slower night than normal. Usually we've had about 5 or 6 calls. Whoops, that's all it takes. There we go. 2 lines are lighting up. Just a matter, as soon as somebody signals me which line to punch up, we'll punch one up here. Line, anyway, we got them both lit up. Just a question of which one is the one that we're going to punch up first. Is it line 1? You're on the air, I think.
Yes. How long can you be held in jail without being Mirandized or charged with something?
There you go.
I was just thinking that that would be an excellent question to discuss. Most people have a misunderstanding about when a police officer needs to read Miranda rights. I think most people have watched a lot of TV and they know that on LA Law or on any of the cop shows, the minute you get arrested, someone reads you your Miranda rights, and that's therefore the way it should be done. That's not the way the law reads. The case Miranda v. Arizona, I believe it was, said that police officers need to read Miranda rights to suspects when both of 2 things have happened. And the 2 key things are what are called custodial interrogation. So one, first part of your question, if you're under arrest, then that part of it is covered, or you have to be in a place where the police officers are dealing with you in a fashion that you don't feel free to leave. That's considered custodial. The other part of the 2-part Miranda test, and they both need to be present for the Miranda rule to apply, is that you have to be interrogated. So if the police say, you're under arrest for thus and so, that's not enough to trigger your Miranda rights to be read to you. They must ask you questions, and not only do they need to ask you questions, they need to ask you questions that are relevant to the offense that you're charged with. So if they ask you your name, your address, your date of birth, that's all okay. But if they ask you, where did you get the gun that you used in the robbery, that's interrogation that applies to the Miranda rule. I guess the final qualification to the Miranda rule, if a police officer asks you questions in custody that relate to the offense, the remedy generally for having done that is if they've messed up and they haven't read you your Miranda rights and ask you incriminating questions, they don't get to use that against you at trial. I think a lot of people think, oh, wow, my Miranda rights were jeopardized. I've got tons and tons of money coming, and that's really not the way the rule works. The remedy for violation of the rule is that the information that the police gathered from you can't be used in your prosecution against you.
Thank you for your question. That was a very good question. I'm glad we finally had that. I think I've had that come up dozens of times, and I think Judy did an excellent job of responding fully to that question. Anybody else have a comment?
One point that kind of follows up from what Judy said is, as you said, that the officers have to be questioning you, they have to be interrogating you. And what you often find in these cases is the citizen is feeling a lot of pressure. They're very nervous. They may be in an unfamiliar environment in the police department, whatever, and they make what are called spontaneous acknowledgments or spontaneous confessions. And if you have a case where the officer is looking with sort of a steely eye at the citizen and says, "What is your name?" and the person says, "All right, you got me, I did it," that may not be a responsive answer, and it may be that that is deemed later to have been a spontaneous admission that can still be used against the person. And so if you're advising somebody of their rights, usually what you tell them is you're supposed to answer questions about who you are and where you live to establish identity. Other than that, the best thing is to refuse to answer any questions till you can consult with your attorney.
Thanks again.
Thanks.
Line 2, is that ready? I presume it is. We'll try it. No. Sorry about that. Probably cut somebody off. Sorry. Well, we appreciate that last call. Brings me back to my days of teaching at the law school, where I stressed exactly the same points that Judy Wang so well illustrated here this evening. Again, the number to call should be on your screen, 542-6228. And we've, again, tried to have a little bit of balance in our panelists so that somebody who's a little bit knowledgeable on consumer rights and bankruptcies is here. And Judy Wang, of course, being with the City Attorney's Office, is very knowledgeable on various aspects of public law, including criminal law. And Mark Connell is knowledgeable in regard to general civil litigation matters. And so between the three of them, we hope to cover everything, cover the waterfront that comes in. The other night, I know we had a question, first night I think it was, an intriguing question of maritime law. And actually, I thought we did a pretty good job of responding in a way. I brought back a moot court case I had clear back in 1969, where we had a maritime law case as our moot court subject. But again, we've got a good 35, 37 minutes, looks like, for your calls. And the number's 542-6228. While we're waiting for whoever I cut off to call back, any other common calls that you can recall getting that might be of interest to people? Well, I know a topic. This is for Judy Wang. This comes up quite often. People, let's say that you're stopped for DUI. And the officer says, "Well, ma'am or miss or mister or whatever the case may be, I believe I have probable cause to require you to take a breathalyzer." Should they take a breathalyzer or not? And if you're going to give a general rule, what would you say to people? Let's assume that they've had a few drinks, but they're not really thinking that they had that much, but, you know, they're not sure.
I can't give any advice on that one. I know I went to at least one plea where a prominent defense attorney says that he always advises his clients to take a breath test, but I think there's a real mixed school of thought on that. I do know that people that feel that they are not under the influence of alcohol and vehemently protest their innocence, who have not taken the breath test, later come in and say, "Boy, I should have taken the test," but I cannot make any recommendation one way or another. I do know that our intoxilizer has passed many certifications and is, I think, pretty well accepted as a accurate measuring standard to determine whether or not someone is legally under the influence of alcohol.
Let me ask you this. What would be the chief drawback of refusing to take a breathalyzer test?
Under the implied consent law, as it is currently enacted, if one refuses to take a breath test upon a first refusal, if you've never been arrested for DUI before, you lose your driver's license for 90 days, and that's a mandatory loss of driver's license, and there's no provision to get a driver's license for work or for going to the hospital or any other reasons. If a person's refused a breath test once before, they will lose their driver's license for a year upon a second refusal. So the refusal penalties are really fairly stiff.
Jim, and we're asked about that on the defense side of these cases. What Judy's focused on is one of the primary considerations. You're concerned that if you refuse to take the test, automatically, as she said, you lose your driver's license for 90 days. The significance of that is that for that 90-day period, the state cannot give you this probationary license, allowing you to drive only for the purposes of going to work or taking your kids to daycare. If, on the other hand, you take the test, let's say you're found guilty of DUI, the law says you lose your license for 60 days, but the state can give you a probationary license. And so if you have somebody who simply can't afford to be without a license, a truck driver or someone else like that, the advice to give them is you may be endangering yourself as far as a DUI conviction, but at least maybe we can keep you with a license you can use during this period.
Sounds like collectively very good advice. We have a new call here on line one. Line one, you're on the air.
Yeah, I have a question concerning the probation or parole system, really how it works. I have a friend that went to jail for 3 years for writing bad checks, and she's been on probation. She's been out now for almost 2 years, well, 17 months, and she happened to go out with some friends and was drinking and got in a fight and was charged with misdemeanor assault, and then they were going to violate her because of the drinking. How does it work? Do they typically send them back to jail, or does that depend on each different parole officer, or how does that work? I'm going to get off and let you answer it, okay?
Okay, thanks for your question.
Yep.
Sounds like one for you again, Judy.
I'm by no means an expert on the probation and parole program. I think the answer is going to vary depending on a number of things. A lot of paroles and probations factors vary. Some people are what's called a dry parole or probation, and it could be, if they're on a strict dry parole or probation, that drinking alcohol would be considered a serious enough infraction so that they could have their prison sentence reinstated and be returned to prison. It could be that the offense would be enough to have that happen. It also could be, I know people that I have prosecuted have been on probation and parole and have committed exactly that offense, have been drinking and have committed an assault, and they were not sent back. The other factors that may enter in is what the initial offense was, whether the initial offense involved violence, and I know in your fact pattern it did not, but that could be another factor. It could be another factor determining whether or not they went back to prison, how many infractions had been filed against them. If they were once a month getting caught drinking on a dry probation or parole, probably about the third time that had happened, they would be sent back to prison, absolutely. But it would depend on the underlying factors there and the probation officer's evaluation of how this particular probationer had been doing under their parole or probation.
Thank you, Judy. We're ready for more calls, and again, the number is 542-6228. While we're waiting for another call, I'd merely comment briefly to reinforce what Judy had just said. I think that we all who practice before the courts and the criminal justice system recognize that there's a tendency on the part of courts to be a lot more lenient to first offenders and make a big distinction between a first offender and a second or third offender. So that the first time you're in front of a court, all excuses are heard and considered, and you're given the benefit of the doubt. But about the second or third time, all of a sudden, things change markedly. Well, again, this is the Dial a Lawyer free call-in talk show. We have 3 Missoula attorneys who've agreed graciously to volunteer their time this evening. So we still have, looks like, a full half hour before the show wraps up. If you have a call, something that you've been wondering about for a long time, or just something that's an immediate concern, if you're not sure whether it's a legal problem or not, feel free to give us a call and we'll respond as best we can, just on the spur of the moment. And of course, you shouldn't expect the kind of full legal advice you'd get after a regular consultation in a normal attorney-client relationship. But we'll try to provide some helpful initial guidance. Any other common questions?
Jim, I was just going to follow up on that last question. One of the things that people who practice in the criminal courts do see from time to time, and it may be unfortunate from a social standpoint, but sometimes the judges have very conflicting concerns when they have a probationer brought back before them that really has clearly violated what they were supposed to be doing. And one of those concerns is that you often hear the judges say, you deserve to go back to prison. I'd like to send you back to prison, but I'm concerned because the prison is so full. And the judges don't work in a vacuum. They do have to consider whether society is prepared to pay the simple cost of putting this person back in that jail environment, which is terribly expensive.
That's right. The studies that I've seen, in fact, indicate that the full cost, counting the cost of capital construction and pension money and so on, of putting someone in prison in the United States on average is $30,000 a year. That's a lot of money. Line 1, we'll take your call. You're on the air.
Hi, I was wondering, how do you clear up a bad credit report that, say, might be 5 or 6 years old?
Anybody know offhand the quick answer on that?
Well, there is no quick answer to that particular
All right.
problem. What you can do is call the credit bureau that has that holds your particular credit report, and typically they will allow you to send a letter, for instance, explaining your side of the credit problem, and they will stick that in your file. The idea being that while it may not expunge the credit problem from your record, at least your explanation of why it's there is there for someone who would be thinking about lending you credit. For instance, you might be looking to buy a house and you'll need a mortgage. And if you have 1 or 2 credit problems on your record, it may be that those credit problems are there because you refused to pay what you felt was an unjust bill. And if that was the case, they still may have it on your credit report, but you could send an explanation in to the credit bureau of why it was you did not pay that bill. And hopefully your banker, when he reviews your loan application, will have a chance to look at that and perhaps realize that he should not consider the 1 or 2 bad credit facts that he may pick up. Likewise, you can go a little bit further under the Fair Debt Collection Practices Act, which we talked about earlier. If a credit bureau has absolutely false information on you, what you should do is, it gets to be kind of complicated, probably see an attorney first, but in general, contact the creditor that sent that information to them and try to have them correct it. If they refuse to correct it, notify the credit bureau that it is incorrect. If they refuse to correct it, then there are some remedies that you can bring against these parties under the Fair Debt Collection Practices Act to force them to correct it, and it also will end up costing them some money. So they are well advised then to look into these matters and clear them up if there's incorrect matter in the credit report.
Oh, thank you very much.
Thank you for your call. I'll mention briefly, I don't know if this is legal or illegal under public radio. I brought a book tonight with me knowing we were going to talk about bankruptcy and consumer rights. There's a book by an outfit that's probably not too popular with lawyers called Nolo Press out of California somewhere, and I can give you the toll-free number, I guess. But there's an excellent book called Money Troubles. And in here, by the way, in Chapter 14, they have a specific set of suggestions for how to clear up a bad credit rating. And what Mr. Turnabene has just said is very accurate according to what I was just skimming in this book. But they have a toll-free number. I see it's 1-800-992-6656. And I think this book is under $20. It's paperback. And I myself, although, again, not an expert on consumer rights, have found their publications extremely useful. They have a little book out on divorce and how to handle your money during a divorce. They have one on Social Security that's very useful. They have a publication larger than this one, specifically on bankruptcy. and they're designed for non-lawyers to try and figure out their problems themselves. So I don't know, I guess I can tout it, probably without violating anything too horrible. Certainly no private benefit to me. But again, we have another call coming in. Is it ready yet there? Not quite. All right, we do appreciate your calls coming in. It looks like it's ready. Line 1, you're on the air.
Yeah, I have a question concerning some a winning award that I supposedly got, and I called and talked to them, and they said that I won one of 5 gifts, and it's not a sweepstakes. It was a frequent flyer thing that I filled out in the airport when I went on a trip, my last trip, and they said, yeah, I certainly had won, and within 3 to 5 business days I would know which large gift I had won. Plus, I had also won 10 other gifts, and that if I chose to accept the 10 other gifts, the only thing I would have to pay for would be the taxes and the shipping and handling on them for a one-time fee of $699. And they said they would get back to me in 3 days to let me know, you know, what I had won, and they were going to come out and get a cashier's check or a check for the $699. And since I haven't paid that, I haven't heard anything from them. Is there anything that you can do to find out if it's legit or if they are ripping me off or whatever, or fraudulent? Is there anybody I can call and talk to?
Mark, any suggestions?
Well, we can tell by the tone of your voice you're rather skeptical about this call, and it certainly sounds like you have grounds to be. The newspaper as well as the legal press is full of cases where people have made these sorts of claims on the phone and they rip off people and they disappear. Obviously, we have no way of knowing whether that's the situation here, but the best advice we could give you probably would be, number 1, don't pay it, and 2, I would call the county attorney's office. They have historically maintained a consumer protection unit that generally gets the first word across, of scams like this that are being perpetrated across the country. And they can tell you whether they've heard about something like this, they can investigate it for you, and probably they can make sure that your money is protected before you put it in the mail.
Okay. Thank you.
Sure. Thank you.
I think just a follow-up on that, I think a general rule of thumb is if it sounds too good to be true, you can pretty much bet that it is. And if it just doesn't sound like I could possibly get this good a deal, well, you probably can't. So
And if
just call local law enforcement and try to get us coordinated so we can check it out and keep more people from being abused by those kinds of scams.
I was going to say, if it turns out that it is that good of a deal, let us know, 'cause we'd like to do it too.
All right. I think as lawyers, we've all seen instances where people promoting one kind of thing of this sort or another, they're just, I've never seen one yet that was really as good as one would hope it could be. We'll take another call. Line 2, you're on the air.
Yeah, I got a question about my girlfriend was going to a beauty college over in Coeur d'Alene, and she had to complete 2,000 hours to finish the course, and the grant that she got paid for up to 1,000 hours, and she only completed 500 and then transferred schools here to Missoula, and they kept the money for the whole 1,000 hours. I want to know if they can do that. Or if they should have to transfer the money to this school, because now she had to take out another loan, for this school.
You want to tackle that, CJ?
Well, let me take a shot at it. First of all, you may have some problems here with the jurisdiction, and what I mean by that is we're in the state of Montana, and I might add we're licensed to practice in the state of Montana, and this apparently occurred in Idaho. Since we can't give you any advice on the laws in Idaho, you'd probably be well advised to talk with an Idaho attorney about it. If, however, the loan to her was from some sort of a federal program for students, then there may be something that can be done by someone here. Probably the best thing to do would be to check with the people that, particularly if it's a federal loan, with people who made the federal loan, to find out what their regulations are in that area and follow up what their advice might be.
All right, thank you.
Thanks for the call. Is line 2 ready? I cut off line 2. Line 1. 1 minute. Well, okay. Line 1, you should be on the air.
Hello?
Yes, I think you're on the air.
I have a question that may sound maybe stupid, but I was wondering, what happens when a person is issued a summons to appear in a justice court? What exactly takes place in this justice court? That's my question.
All right. Well, you want to take that? Typical process in a JP court?
Sure, I'd be happy to. If you've been issued a summons, typically that means that you've been sued. The two documents that you're aware of generally are a subpoena, which is an order of the court for you to appear as a witness, or a summons. A summons usually comes to you along with a copy of the complaint, which is the document that the person suing you files with the court. In justice court here in Montana, it's usually a fairly informal procedure, and the complaint may or may not really tell you what the person's asking and why he feels he's entitled to it. But when you get a summons, you're told on the summons how much time you have to file an answer in the court if you don't agree that the person's entitled to what he or she is asking for from you. So the first thing to look for is the copy of the complaint, to see who it is that's suing you and why. And then secondly, be aware that you have to file a document in court within the time period they give you, or the court can give judgment by default to the plaintiff. That means that after that period of time elapses, you will be found to have given up your right to contest it. And the court may enter a judgment in a certain amount, maybe several $1,000s against you, and begin to take away your paycheck or take away your property to satisfy that. So the main thing is find out what they're suing you for and respond quickly.
Did
Well,
that
thank you.
answer your question? Thank you for your call.
Yeah, there's one little extra thing here. I think we got off on the wrong track. To begin with, this is a felony summons to appear to answer a complaint that I don't care to mention at the moment because it'll have to go to court to be satisfied. But this has nothing to do with any money owed or anything. And this is a complaint against me for something that I obviously, well, it has to be decided in court, but it has nothing to do with any money owed or any being sued or something. So what happens in that case when you have to appear and they have a felony against you and you have no attorney? You just show up in court and say, here I am, or what? And then what happens?
Right, well obviously it's a different type of summons, you're right. When you get a summons, again, whether civil or criminal, it's an order of the court for you to appear. You must appear. In a criminal case, if you don't appear when the court tells you to appear, typically a warrant is issued for your arrest. So the first thing is make sure you don't miss that court date. The second thing is, before the court date, if you can afford to retain an attorney, talk to somebody. Even if you don't spend a lot of time, get some sense of what your rights are. But let's say that you don't have an attorney and the day comes when you're supposed to be in court. If you go to court, typically what will happen on that first occasion is simply that the court will advise you of the specifics of the charge against you. The court will make sure, will address the question of should you be out on bail or bond, or can you be released without a bail or bond on what's called your own recognizance. And then if it's a felony or any other offense for which you could be jailed if convicted, typically the judge will advise you that if you can't afford an attorney, the court will appoint one for you at public expense. And so generally when you get a summons like that, the best advice is to not miss the court date, to probably not make any statements to anyone other than an attorney, and when you show up at that court date, either have your own lawyer or be prepared to ask for a lawyer at public expense.
Thank you very much.
Sure.
Maybe while we're waiting for our next call, Mark, you've already started this process, I think, in your last two answers. Could someone talk about the course of a normal lawsuit? Maybe we'll start with civil and then move on to criminal. Just kind of give people an idea of the exchange of papers and what takes place. Yeah, if you wanted to continue.
Sure, I'll be happy to. In most cases, a lawsuit is almost inevitably is begun by the filing of a complaint. Usually, people hear from the other side's lawyer before you actually get into court. You have some sense that people want to negotiate or work out a settlement, or you receive a specific demand from the other side. But if you can't resolve things out of court, you get a lawsuit filed against you, then you file an answer. And again, as I mentioned in the last call, you have a certain amount of time to do this, or you face the possibility of not having the ability to contest the other person's request. But you file an answer. And then, depending upon the complexity of the case, the parties try to work it out among themselves or their lawyers. And if you can't do so, then you begin this process that we call discovery. And that's an opportunity both sides have to send written requests for information and to take formal statements from the other side to try to learn what the facts are. And the purpose of that also is to give each side a chance to interview the other witnesses to see how they'll appear in court, see how strong they'll sound. And when that pretrial discovery process is over, which can take months, sometimes it can take years in a complicated case, but when that pretrial discovery process is over, then our courts today are beginning to require the parties to engage in settlement negotiations, typically with a settlement master or a mediator, again trying to save the court the time and expense of going through a full-blown trial. And if that's unsuccessful, then you get your day in court. And depending upon the type of case, it can be with a jury or without a jury. And it can be very complicated, or you can have a 2-hour trial. These things don't have to be that complex.
Let me follow up on that question briefly, if I may. You touched upon a point that I know that many lawyers have chatted about casually over lunch with me, and that is this whole area of discovery, which has gotten to be a very big, extensive, and expensive proposition in civil litigation. I'd be interested in the views of everybody on the panel this evening about what you think about the scope and extent of discovery. Should it be greater? Should it be automatic, like they're talking about doing? Should it be less? Should we go back to the old trial by surprise, or should we just do the opposite extreme of requiring divulgence of just about everything you got, or forget it, or something in between? Anybody have any general responses? I'd be interested, just putting you on the spot with that one real quick.
Well, my general view is that the system right now, in a great number of cases, is being abused by too much discovery. You know, this discovery costs money. You have to pay your attorney to do all of that, and quite often it gets so burdensome that the parties cannot get their day in court. When that happens, I think that's the system has failed, and obviously we've gone too far. Conversely, there are situations where the matter is so complex. For instance, you get into battles between corporations over their course of conduct over many years. The discovery may necessarily be extremely burdensome, and it may go on for some years in order just to find out what is going on in the case and what each side has in the way of evidence. My personal view is that what we should do is have a system in which the courts limit discovery to some degree, but are willing to open it up in those cases in which the courts see we have a complex matter that requires that kind of discovery. I think that way we would ensure people's access to the court system, because if we don't have access to the court system, we're going to become an anarchy, and we don't need that problem for our society any more than we already have it.
Anyone else willing to tackle that large topic?
I guess I was thinking I'd like to move on to a combination of a couple of the questions you asked earlier. One of the most common questions that we're faced with and tracking a criminal case through the system. I know a lot of people ask, what's a criminal case? What's a civil case? I don't understand. When is which what? A criminal case involves a governmental agency, generally the state of Montana, or sometimes a municipality like the city of Missoula, charging one person with a violation of the law. My favorite example, and if I can use Mark for just a minute, if I reached over and punched Mark in the face right now, there's a possibility of at least 2 lawsuits. One is a criminal lawsuit where everybody that's watching the TV show could conceivably be a witness, and you folks as well, and the camera members, where I've broken Montana's law on misdemeanor assault. I've just punched this guy in the nose. I knowingly or purposely caused bodily injury to him. I'm going to be charged criminally, probably within the municipal court, and have to face prosecution and potentially 6 months in jail and a $500 fine. But in addition to that criminal lawsuit, I've just created a civil lawsuit for Mark. Mark had a very nice nose. I've just busted his nose, and he can sue me for pain and suffering. He can sue me for his plastic surgeon's surgery job to fix his face, and he can sue me civilly for damages because I've just wrecked his face, I've hurt him, and I've caused him to miss work, caused him to need health care, and a number of damages there. So the civil suit is Mark suing me for hurting him personally and financially. The criminal suit is the state of Montana or the city of Missoula suing me for violating the criminal law. And if I could just go through the criminal lawsuit for just a minute, similar to the way Mark went through, I'm going to be charged, as one of the callers mentioned, I'm either going to be arrested or I'm going to get a notice to appear in court. I'll be read what the charge is that's filed against me, a misdemeanor assault. And I'll be given an opportunity to plead guilty, which would resolve the criminal lawsuit right then and there with a guilty plea and a sentence. Or I could plead not guilty and we could proceed towards trial, and we would have a similar, though less extensive, system under the criminal system, that there would be discovery. We could put out a notice on this particular TV show. Everybody that watched the TV show on September 29th, did you see Judy Wang punch this guy in the face? And we could get names of witnesses for the criminal case, and then I could proceed to trial again, either a jury trial or a non-jury trial. At the end of the trial, then I could be sentenced for violating the criminal law, in addition to having my lawsuit and Mark's judgment against me for all the damages I've caused him.
Judy, I might mention, you sounded very enthusiastic when you gave that example.
Actually, I'm a pacifist, and I have a very weak fist.
Okay, I think we're getting a call in shortly. And while we're waiting for that call, I'll mention that our next show is scheduled for October 27th, which is the final Wednesday of October. And I'll mention who our panelists when we get another break. Line 1, you're on the air.
Yeah, I had a question about small claims court. Is there like a statute of limitations or a time lapse that makes it too long that you can't file against someone? And what is the limit that you can sue for in small claims court?
Somebody know the answer to those?
I think I know some of the answers. First of all, in the general idea of small claims court was to allow people to go in without an attorney and get a resolution of their claims against each other. That has gone by the wayside to some extent because everyone has a right to an attorney if they want one. However, most attorneys do not try to practice in small claims court because the amounts involved are too small, and so the system continues to work without attorneys. The jurisdictional limit, the amount that you can sue for in small claims court, keeps changing, and I might add the new Montana statutes that our legislature so kindly passed last time are going into effect on Friday, so I can't tell you what the new law might be by Friday. However, I believe right now the limit is $4,500. What you do in a small claims court is really no different than what Mr. McConnell was mentioning as far as a lawsuit goes. You go in and you get your evidence and you tell your side to the judge and the other side tells their side to the judge, and then the judge makes a decision, and as long as he stays under the jurisdictional limit, then you've got yourself a judgment.
Okay, if you sue the person for the maximum amount that you can sue them and they choose to get a lawyer, does that automatically force you to get a lawyer and for it to go into some other kind of court, or can you just go ahead and continue to fight against their lawyer?
Every person in America has a right to represent themselves, so you do not have to get a lawyer on your own. You can go ahead and represent yourself. However, I'm fond of telling my clients that to me it's very similar to having a broken leg and deciding whether I'm going to set it myself or have a doctor set it. Personally, when it comes to broken legs, I prefer to have a doctor settle it. The other part of your question, you asked about statute of limitations, and that's a very complex subject, but let me just touch on that for a moment. 4 different types of laws. There are different lengths of time in which you have to go to court, or else that claim is forever lost. To give you an example, the most obvious is automobile accidents. You have roughly 3 years to bring your claim for what we call negligence, and that's what most automobile accidents would come under. For an open account, it's 1 year. For a contract action, it's 8 years. There are other, this is a generalization now, there are other statute of limitations. So it depends on the matter you have, what the statute would be in that case.
This was for a dog attack and loss of income because the dog attacked my dog and I lost puppies, and now my dog isn't able to have any more pups because of that particular incident, and that's $900 a year that I don't get now.
All right, that would probably come under the negligence action, and that would be a 3-year time limit for bringing that claim. So the idea then is that after 3 years, that claim could not be brought. It certainly is not as a negligent action. There may be some other reason it could be brought.
CJ, I might add that, as CJ was indicating, that the statute of limitations sometimes can be conflicting, and it's hard sometimes to figure out which one applies. There's a separate statute that talks about damage to property. In that case, it can be 2 years.
Okay.
And so my guess is you could have a 1, 2, or a 3-year statute, and the sooner you do it, the less you have to worry about that problem.
All right, thank you.
Thanks for your call. We'll take a call from line 2. I guess you won't. Okay, I think we have about 3 or 4 minutes left, and we've still got time for a couple of calls. And, again, the number is 542-6228. And we've had some wide-ranging calls this evening. Looks like there's a couple coming up. As soon as we get them screened here with their ruthless screener in the other room, we'll patch you through. Looks like we're just about there with a call from line 1 and 2. Which one? Both? Either one. Line 1, you're on the air. Hello?
Yes.
Okay, I think you're on.
Okay.
You might want to be back from your TV a bit.
Okay. Is that okay?
Sure.
Okay. I've got a question in regards to, well, here's the scenario. We are the receiving end of some state money through a daycare. In other words, we provide a daycare service for someone else. This is the first time we've ever had to deal with this, and we've been doing this for about 10 months, roughly. Through this process, as of late, we have found out that the parent who was supplying the children, of course, was knowingly holding back money from us without us realizing it. We have since found out and are talking to the state right now. Is this now a state matter versus her, or do we have some kind of a civil case in this?
Okay, we'll have to be awfully brief. We're being signaled that we need to wrap up. Anybody got a quick answer on what they ought to do? About 10 seconds.
Sure.
I'll do it real quick. I think if you've lost some money here from your business, then you may have a civil action. If not, this is probably a criminal matter between the state and the individual involved.
Okay, well, we'd like to thank all of our listeners for the calls that we've had. Is there time for a call from line 2 then? Okay, we'll take a call from line 2.
Hello?
Yeah, you're on the air.
This deals with mental incompetence. 3 questions. One is, at what point are the attorneys obligated on a person that might be incompetent? 2 would be signing of a deed. 3 would be filing a lawsuit. In other words, if a person has been, say, diagnosed as schizophrenic, hallucinatory, paranoid, then those 3 areas, would that be sufficient to, we'll say, hold up being incompetent? Signing deeds, rules of professional responsibility, and the other one would be filing a lawsuit that a person might have to defend.
Okay, and we'll grab that one, jump right in.
Well, I'm not exactly sure what your focus is. One thing we can say right off the bat is that if someone is mentally incompetent and has some rights they're seeking to have the courts address, they can file a suit through a next friend, or generally a guardian. So they're not precluded from proceeding. An attorney, you're talking about an attorney who's representing somebody who's mentally ill?
Yes, at what point is he obligated to either bring it to the court's attention or cut and run?
Well,
Under the rules.
an attorney's got an obligation not to file cases that he hasn't reasonably investigated and make sure that there's something to them. If he learns in the middle of a lawsuit that his client is not mentally capable, probably
Hello, welcome to Dial Lawyer. I'm Mike Fellows. Our regular host, Jim Moranti, couldn't be here tonight because of some unforeseen circumstances. But Dial Lawyer is a show where we try to give some general advice from our expert panel of attorneys about questions that you may have. And if you'd like to call in, our number here at MCAT is 542-6228. And on my left here is John Ellingson from Ellingson & Moe. Next to him is Neil Leach, another attorney at law. And next to her is Yvonne Wells, our expert panelist of attorneys. If you have any questions, like I say, our phone number is 542-6228. One of the things in the news recently has been the Reginald Denny beating. You know, people have seen the videotapes of the three accused beating the suspect. As far as jury rights go, is there anything that would have precluded them from a guilty verdict? Anybody? Neil?
I haven't been following. Have you, Yvonne?
I really haven't, and I don't practice in the criminal arena at all. I guess my impression of what I have seen on Court TV, which is one of my favorite television shows, of course, is that, it seemed to me that the charges that were brought against the defendants, inciting a riot and those types of things, they just weren't able to prove the charges that they brought, and it seemed like there was some question about identity of the defendants and so forth on the videotape. So, it's hard for us to say what should have happened or what shouldn't have happened. I think you get the people in the jury together and they make their decisions. I think the biggest concern was the pressure on the jury and the unusual things that happened during the jury deliberations.
I know they had 5 excused jurists. Is that common in criminal cases usually?
Not usually. Usually I think in a felony case, you get 6 6 people that you can preemptory challenge and drop off the panel. A lot of times, I hear people who complain about the jury had this verdict or the jury had that verdict. But if you go back and think about it, the jury system in our judicial system and the part that the jury plays is the most important part we have in this country, at least in my mind. And we're not sitting there with the facts. They're sitting there listening to the testimony. They're watching the witnesses, deciding who they're going to believe and who they're not going to believe. And I think the whole idea here is that you take 12 people from all different courses of life and bring them together, and they're going to be smarter than one judge. They're going to be more intelligent than a defense lawyer or the prosecutor. And that's why when these people get together, they literally have shouting matches a lot of times. And there's a lot of tense emotions going on. And for us to sit back and second guess a jury, you know, I don't feel comfortable with it. You got to trust the jury system. And I'm not saying that they're infallible, but I think it's the best we can possibly have.
That's a real good point that you make about the jury being the body that sees the evidence that's presented to them through the court system. We all form impressions of whether a person might be innocent or guilty, all of us who are not on the jury, through the media.
Yeah, through the newspapers.
Through what we read in the newspapers, through what we see on TV. It's important for all of us who are not on the jury to remember that that's not necessarily what the jury is seeing. And that is not necessarily the kinds of impressions that they're getting in the course of the trial. So for anyone who hasn't literally sat through the trial from start to finish and seen the evidence just as it was presented in the courtroom to make a judgment as to whether or not the jury made a mistake or was correct is really impossible. We can't put ourselves in the place of any of those jurors unless we've actually been there.
So if there is some reasonable doubt within the jury's mind, then that can have an effect too.
Absolutely. It's a very difficult standard to find someone guilty beyond any kind of a reasonable doubt. And as I understand the Denny situation, the defendants were found, most of the defendants were found guilty of some crimes. But there was a question as to whether or not some of these defendants actually intended to murder, intended to kill with premeditation. I can see a lot of reason why a jury might have, an individual juror might have difficulty with that, given the context of the riots that were going on.
And I know there's a group in Montana that talks about a fully informed jury, that the juries have certain rights above and beyond just finding the defendant guilty or not guilty, that they also can find the law either guilty or not guilty in respect if it's a bad law or something. Would you?
Yeah, I'm with him. I agree with him. You know, implicitly, I think that the jury has that kind of a power. The jury can make a decision as to whether or not this person's guilty or innocent based upon the fact that they may not like the law. Now, they're not supposed to do that, but I think it happens anyway. And many times, you know, the jury might see something and say, look, this is just unfair. This is not right. We're going to make it right. And I think that that's what part of, you know, the fully informed jury is about. And getting back to this whole system of juries, you know, and what we get through the media and what's put in the press, you know, people come up to me, they say, well, how could that person have gotten, you know, $12 million for emotional damage? I mean, and you hear it all the time, you know, the whole insurance crisis that was put on by the insurance industry. That all comes to us through the media. You've got to actually be there in the courtroom, hear the witnesses testify to find out, you know, why that person may have got a large award. It may have been something like the insurance company did everything they could within their power to literally destroy a person's life. And until it's brought out on a bad faith issue and the jury hears it and delivers its verdict, people can't understand. Like John says, until you've been there, you can't imagine and make a good decision as to why that verdict was returned. And it's not infallible. There's been mistakes made. I mean, there's innocent people in prison, you know, and there's guilty people out in the streets. But we just got to do the best we can through our jury system to make sure it doesn't happen very often.
I'd like to remind everybody out there that you can call in with your questions at 542-6228. We'd be glad to answer any questions you have from our expert panels of attorneys. Another thing that was in the news recently is the Roth case with the elder abuse, and I know that with some elderly people that tend to handle their finances over to powers of attorneys, that sometimes financial abuse occurs.
That's true. I think that it's a very difficult issue in society right now, particularly as the population is aging, and you have larger numbers of people who have a lot of money, and as they age and get weakened physically and sometimes mentally, they're easy prey to people. And those are extraordinarily difficult issues because sometimes the elderly person has a legitimate desire to do one thing or another with their money that might not include their family. And that's hard for a family to understand. On the other hand, there are unfortunately too many people out there who are willing to take advantage of the situation and try to ingratiate themselves with these elderly people solely for financial purposes.
So if somebody's not happy with their power of attorney, how would they regress the situation?
They would revoke the power of attorney.
The power of attorney is only valid until it's revoked by the person who grants the power of attorney. Some power of attorneys survive what we call disability, and those are called durable power of attorneys. So for instance, if your mother gave you a power of attorney and later she became incapacitated, if that power of attorney had been what's called a durable power of attorney, it would be valid during the time she was incapacitated. Now, some power of attorneys are just general, and in that case, if the person becomes incapacitated, the power of attorney is then null and void. So you need to look at the specific type, and I would just recommend that anybody who's looking at these issues consult an attorney relative to both revoking them and granting them in the first place.
I see some troubles in the fact that if they're placed in a nursing home or a personal care home or some of those kinds of situations where they end up giving up most of their rights, you know, to how they deal with their house or their finances and those kinds of things. And
well, there are some alternatives to powers of attorney, and when I advise my clients in terms of powers of attorney, I ask them about the trust situation, and do you implicitly trust this person to carry out their wishes? And in most cases, it's a son or daughter or brother, sister, family member. If there's any doubt or question in that person's mind, and I know they can't always predict how a child would act when faced with a situation where they have control of some money, but if there's any question whatsoever, there are other mechanisms such as trusts. There are different types of trusts which can be set up to protect that person's assets during the lifetime and ensure that the property remains intact to the degree possible, or is used for the purpose that it's meant for, and that's to take care of the person whose money it is. So there are some alternatives, but I agree there is a lot of abuse out there, and my experience is that we have had some help from the city police department, the city attorneys, the county attorneys. When you find someone who's abusing elderly persons in the financial sense, if it's a common scheme, if this is something that they have done to more than one person, then the law on the criminal end will get involved and complete some investigations. And I know there have been some of those in Missoula in fairly recent years. So that's another angle of it, but you generally don't see that arise when you've got abuse of a family member or something to that effect.
But even if it's not a common scheme, there are remedies for the person who's being wronged. If a power of attorney is being abused, and if the abused person has an ally or has the ability to seek an attorney, there are things that can be done to put a stop to that. Because a person who has been designated as the attorney, in fact, through power of attorney, has an obligation only to act in the best interests of the person who they're acting on behalf of. They can't use the funds for their own benefit. Similarly, even if a conservatorship is established, which is one of the mechanisms that we use periodically to take care of someone who can't manage their finances, the conservator or the trustee has an obligation only to act in the best interests of the person for whom they're employed. And if they fail to do that, there are remedies. You can kick out the trustee, you can kick out the conservator, and if there's been misappropriation of the funds, you can obtain a judgment to have those funds paid back.
That's the next question is, how early should people get wills? I know that a lot of young folks don't really think about wills or ask an attorney, and you see a lot of, not necessarily ads on TV, but ads on the radio for mail order wills. Call now and order your self-made will, and make it out. What do you feel about that?
Yvonne,
Well,
you can handle it first.
I
think we probably all feel the same way.
Obviously, you know, we don't feel that's the way to go. You cannot take one standardized form and say this is going to fit everybody's situation. And most people, once you start reading a will, the language in there is such that you probably don't understand what it says anyway. So a lot of it, I mean, it took a long time and a lot of education to try and figure out why is this particular provision in there. And so obviously we don't recommend that. As to when someone should get a will, I think it's critical if you have children, because you've got to make provisions for those children in terms of who's going to care for those if something should happen to the parent, who's going to care for the children, who's going to take care of the financial obligations for the children, those types of things. So I think it's absolutely critical at the stage when you have children, and I know we recommend that everybody who has property have wills, but I think that's a big issue that people need to look at.
Okay, looks like we have a call. Let's go ahead. Hello, welcome to Dial Lawyer. Can I take your question?
Yes, I was just wondering if a judge awards the maximum amount of child support in a case, can an ex-wife come back like a couple years later and seek more?
Yeah, it seems like can a person, ex-wife, come back and ask for more, or an ex-husband?
Sometimes. The maximum is not something that is established for all times. It is the maximum under the circumstances, the financial circumstances existing at the time of the award. And if the financial circumstances of the parties change, of the former husband and wife change, then one or the other of them can go back to ask for either more or a reduction. Child support, the judges are required to consider the Montana Child Support Guidelines, and these guidelines provide for variations.
Okay, thank you.
Just
Yvonne, did you?
Well, I was
you
just
had
going to
some
add
further
to
comment,
that.
I think.
Under the guidelines, I believe that these child support awards are to be reviewed automatically every, I believe it's 2 or 3 years at this point. And Child Support Enforcement Division is actually, I believe, charged with the job of doing that, but practically speaking, I don't think they have the manpower to really do that. My feeling is that it can be reviewed at any time. Whether or not it will be changed is another question. And I think, you know, again, if the circumstances are exactly the same as they were 2 years ago, you're probably not going to look at a big variation in what the award was. However, if someone has lost their job or moved or any number of circumstances that could change the amount of child support, if the children have special needs, those would all be bases for changing the child support award. And there are many attorneys who can calculate child support, or at least give you an estimate based on the new guidelines. And again, these guidelines are in a state of flux all the time, and we're working under a fairly new set of regulations now.
So how hard is it to collect if, say, the husband is not willing to pay child support?
The procedural process isn't too bad. The problem is that first you got to know where that person lives so that you can serve them with the paperwork. And then if they show up, oftentimes they may not have any money. If that occurs, you brought them into court and they have nothing, then the court could find them in contempt and fine them or put them in jail for a while. You know, it's a lot of times it's difficult to find to get hold of delinquent fathers or mothers, whoever might owe the child support, and actually bring them to task and make them pay it. You know, but there, like John says, there's remedies there to make it happen. A lot of people who come to me or Yvonne or anybody, I suppose, oftentimes it costs money to hire a lawyer, and you know, the people who come to us many times are people who have no money. And you know, it would be nice if all the lawyers in the world would work for free, but unfortunately we have to make a living too. And I think that, you know, at least the three of us here take our share of cases where you know, we help people for free or maybe at a reduced wage. But you can only do so much of that, and there's a tremendous amount of people out there who need legal services that simply can't afford them. The child support division will help someone who has no money, but usually what they tell people is that they're 6 months behind and they can't get to it right away. So there seems to be a vacuum there that needs to be filled, and I don't know how to do it. Klaus City over at the Montana Legal Services can only do so much. Under the Reagan administration, they reduced his funding dramatically. So it's a real problem for a lot of people.
I still advise people to get into Child Support Enforcement Division and open a case if they're delinquent, and I believe you have to be 2 months delinquent before they'll open a case. But at least the case will be open, and they do have some access that we as private attorneys don't have. They're tied into government computers in terms of tax returns, workers' comp benefits, those kinds of things, and oftentimes you can be compensated for back due child support directly through the government. But again, it takes time. It's not a perfect system. The other thing that I just wanted to add is there is a mechanism for payment of attorney's fees when there is a child support award, and generally I think our courts are real good about making that award of attorney's fees to the victorious party, generally the woman who hasn't, or man who hasn't received their child support. However, again, it's very difficult to collect unless the obligating parent has assets. So what we do, and what child support also does, is search the records. We look for real estate, cars, boats, any titled kind of property, and see if there's a mechanism or property that can be seized for payment of support. And if that property's there, we can be very successful in collecting child support. But if there's no property, if there are no regular wages to garnish, it's very difficult.
All right, we've got a call on line 1.
All right.
Welcome to Dial Lawyer. Can I take your call?
Yes, good evening. I have a hypothetical situation. Supposing an elderly gentleman has deceased and has a life insurance policy whereby there has been no beneficiary named, but he did make a verbal commitment in front of just only 2 people. But nothing was formally put into writing, or nothing was done with a lawyer. Would a person have a chance challenging the life insurance policy, or is it mandatory that you have to have a written will or a named beneficiary?
John?
Well, you don't have to have a named beneficiary on a life insurance policy, but if you don't, then it goes into your estate. And so the question that that you ask is, you're asserting the existence of an oral agreement to have the life insurance paid to you, hypothetically, and you're asking if that oral agreement is enforceable. I think that there are a lot of practical and there may be statute of frauds questions involved in that. I think it's a very difficult situation. It would be very problematical.
One thing I might say is that does the elderly gentleman have any heirs?
None.
No heirs. Okay.
No heirs. Just a young man who was very diligent in rendering services for him, did all of his shopping, was very kind, made all the funeral arrangements, bought his suit after his demise, and just took total responsibility. And when he did tell this fellow that he would, take care of him at some point in time, he just passed away very quickly. And the young man who took care of him, has some learning disabilities and himself, and just never saw the necessity of contacting a lawyer or getting him to name a beneficiary before his demise.
This has brought up a couple things. First of all, when there are no heirs and there is no will, generally the property will, what we call a sheet, did I pronounce that correctly? That means it will go to the state.
Right.
So it's the state versus the do-gooder. But you've raised some other facts that make me think that maybe he would have a claim because he relied on this promise when he provided services. So
not really. I mean, he's just a kind person, and you know, he just told him not to worry about it.
Sounds like a tough case.
So this is something that a will might very well fit in.
Definitely, had he had a will or even put the young person as beneficiary on the insurance policy, obviously there
No,
would
he
be
never
this
did.
problem.
He never put anybody, but he did make this statement in front of a couple witnesses, I think. And there are several different people who know what his intentions were.
Well, I think the intent of the testator is real important, and I would hope that if it came before a judge, that here you have perhaps the state of Montana or the federal government on one hand, and the person who helped this elderly gentleman out, you bring the witnesses in, you establish the intent of the testator. I would certainly hope that a judge would rule in the young man's favor who helped him out.
I think he should seek an attorney, and at least, you know, perhaps there are cases out there that we're not familiar with or something that could assist him, but I think he or someone on his behalf needs to speak with an attorney and tell them all of the facts and from beginning to end to determine whether you do have a case.
Okay. Thank you very much.
You're welcome.
Thank you. So it's very good that they get these things in writing first before things do happen.
Absolutely, and you begin to see some of the factual complexities that might present itself in any one case that have to be thoroughly investigated before you can say, yes, you probably have a case, or no, you don't.
Now, are verbal contracts, how are the legality of verbal contracts in Montana?
Well, just because a contract is oral, it doesn't mean that it's unenforceable. It just means that it's probably a little bit more difficult to enforce than a written one.
Okay, we have a call online too, so. Hello, you're on our lawyer. Can I take your call?
Yes, I was wondering, I recently got a divorce, and I have a son, and it didn't state in the divorce decree about taxes, the tax deduction. And I was wondering, he pays child support, and I was wondering if I would be entitled to that deduction.
Are you the primary custodial resident? You have the child more than 50% of the year?
Yes.
Then, in that event, my understanding of at least the federal tax code is that, yes, you would be entitled to the child as a deduction. Generally, those are a part of the divorce decree, and there is also a separate form that should be filed each year by the party giving up the deduction if you're actually entitled to it by virtue of this 50% rule. So I believe that yes, you could do that. Do you agree with that, Neil?
Yeah, I guess one of the considerations I'd look at too is whether or not, I mean, how much, this is just a factor, is how much child support does the ex-husband pay, and under the Montana child support guidelines, it's delineated from each person's income and assets what each person's obligation is. For instance, say if your obligation is maybe $5 a month and the ex-husband pays you $550 or $600 a month, you know, there's an equity issue there too as to who should be allowed the tax exemption for the child. Ultimately, it's going to be up to the judge, and Yvonne, of course, knows more about the federal tax code, but there could be a problem if both parties claim it. I think it's something that needs to be resolved either through communication with your ex-husband, if that can be achieved. If not, you may have to go to the courts.
A couple ways I've seen this done. It's very common for people to alternate the deduction every other year. If we've got one party who has significantly more income than the other party and the deduction would benefit the one party, oftentimes the party who it would benefit more receives the deduction, and then the other party is somehow compensated in some amount for that. So there are a lot of ways to handle that by agreement, but at this point, absent an agreement, I believe you are legally entitled to claim that deduction. These are things that I always deal with the accountant, however, and if you use an accountant, I would certainly recommend you discuss it with that person.
Does carrying health insurance matter any?
That does not directly relate to the deduction. Again, it's one of those equitable things that Neil talks about. And if the other party is making all these payments and decides to go back to court and ask for the deduction, it's likely that that person will get the deduction at least part of the time. So while in your situation where you don't have either an order or an agreement, I don't think it matters, but it could be something that would be looked at by the court in the future should the issue come before the court.
Okay, thank you.
You're welcome.
We've also got a call on line 1, so we'll go ahead and... Oops. Hello, you're on Dial Lawyer.
Uh-oh.
What's the law for kids that are caught taking drugs?
Could you repeat that?
What's the law for kids that are caught taking drugs?
I was asking what the law is for kids taking drugs.
Well,
Neil, that's up your alley, isn't it?
What can happen to you is you can get dragged into youth court, and you got to go in front of the judge and explain your actions to him if in fact you've been taking drugs. And children aren't treated as adults are in the criminal justice system. They're not really criminals. They just do criminal acts sometimes. And probably the first time you're caught, you may have to go to counseling. You may get some probation, some probationary rules. You would probably get a juvenile probation officer, and if you kept doing drugs and you kept getting caught at it, the consequences get much, much more serious, to say nothing of ruining your own body by doing it. But like I say, children aren't treated as criminals, except for they do have to go in front of the judge, and they are going to face some punishment. And all I can say is that if you keep doing it, it just keeps getting worse and worse.
Particularly after you become an adult.
Right. You know.
And you're no longer treated as a child.
That's right.
Okay, thanks.
So one of those kinds of laws, necessarily the identity of the accused is usually kept, is not published, I believe, right?
Right. They're usually closed hearings, and you know, juvenile law is really interesting. It's a chance for people to really make a difference one way or another, and of course, sometimes it doesn't help no matter what you do. But it's a very interesting aspect of law, and when I was a public defender for many years, it was one of my favorites. There's a chance when you might really be able to do some good, you know, and I think that that's why a lot of people, you know, and not everybody, I mean, some lawyers, you know, they want to become lawyers just to make a bunch of money, and that's not right, but it's there. A lot of lawyers want to be lawyers because they want to have the chance to help people. And, you know, we were talking before the show about how many lawyer jokes there are, and you know, I'm getting sick of hearing them, and I think most people are, well, at least most lawyers are. But, you know, when you think about it, aside from some of the lawyers who just want to make a bunch of money, I think that there's a tremendous amount of lawyers who came into this profession with the sole purpose that they want to help people in some way, and I think that that's an important part of being a lawyer. And in juvenile court, I found that I could oftentimes make the most difference, and that was a really fulfilling thing for me.
Okay, we've got a call on line 2, so we'll go ahead and... Hello, you're on Dial Lawyer.
Hello, I have a hypothetical question. You bought a large piece of land somewhere in Montana, and you were not aware of possible illegal substance growing on this land, say marijuana or psilocybin mushrooms, and it was growing naturally. You bought this land. Could you be charged with a felony, possibly?
I don't think marijuana or psilocybin mushrooms grows naturally in Montana.
What if it did?
Well, you know, I think what you have to have is you have to have knowledge and you have to have intent, and at least to be criminally prosecuted. Now, That's not true with the federal drug laws in the sense that you don't have to have intent. But I still think it would play a role as to whether or not the federal government could actually take your land from you. You know, obviously it's a different story if you're growing them yourself or you know someone else is growing them. They're on your land. Does that help?
Well, say somebody else started growing them before you even bought the land and you had no idea they were there.
Yeah, I don't think you could face, you know, you could still face criminal prosecution. And of course you have your presumption of innocence, and I think it would be a hard time by the prosecutor proving beyond a reasonable doubt that, you know, you were actually knew or that you were part of this growing operation. But on the other hand, you know, you got the land, the pot or the psilocybin mushrooms is on your land. Now that's strong evidence. Now you hope the jury will make them prove their case beyond a reasonable doubt before they're going to convict somebody and send them to prison. I mean, that's our hope. Like I say, it doesn't always work out.
But the longer you hold on to the land, the greater the circumstantial evidence would be that pointing to you actually having knowledge of it. And once you have knowledge of it, it's an easier step to prove intent, which is required under the criminal law. If you only had, if you would only literally purchase the land a week ago, 2 weeks ago, and if it was a substantial acreage, and if it was only on a very small part and a remote part of the acreage, then it's much more difficult to show knowledge and intent. But you change those factors around, and it becomes a much easier case to prosecute and be found guilty of.
Okay, thank you very much.
Thank you. What do you guys think? Are the federal drug laws too stiff for most people? If they have an ounce or something in their possession?
You know, I mean, the feds aren't going to prosecute somebody generally with an ounce of pot in their possession. They'll refer it over to the state authorities. I think the federal drug laws are too stiff, and in fact, they're oppressive. They have mandatory minimum sentences for first-time offenders. They send people who smoke pot, who sell pot, to prison for a substantial number of years. And quite frankly, I don't want to pay for those people to be in prison. As a citizen, I don't want to pay the $20,000 a year it takes to keep those people in federal prisons. Our prisons are overcrowded. They can't handle the people we have now. We are literally, you know, exceeding our national debt just by trying to keep these people in prison. The answer isn't prison. The answer is getting to the kids. Like, you know, this DARE program, my son asked me if I knew this Officer Jacobson from the city. And I said I did. You know, Officer Jacobson is a real nice guy. He goes to the fifth graders and talks about the DARE program. That's the answer to helping this country solve any problems it may have with drugs.
So education is the key.
Is education with the kids. Every time you pop a dealer and put him in prison for 5 or 10 years, another one takes his place. It's a war that can't be won. And, you know, we got to look at rehabilitation. We got to look at other things other than putting people in prison and making us as citizens pay for those people to sit behind bars. I'm tired of it.
Education's a part of it, but rationality in the drug laws is another part of it. We treat drugs like marijuana similarly to drugs like heroin and cocaine.
Right.
There is a vast difference between those kinds of drugs. And then on the other hand, we ignore drugs to some extent like alcohol, and we ignore almost completely cigarettes and nicotine. Where's the rationality in our system? I think that it's very difficult for children to feel that they've been consistently educated when they see such inconsistency with the drug laws.
And we've got a call on line 1, so why don't we go ahead and we'll take that. Hello, you're on Dial Lawyer.
Hi. This is a question about criminal procedure, I guess. Is there any appeal of a parole board hearing a decision on a revocation? Where do you go if you disagree with the parole board hearing decision?
I think that must be for you, Neil.
Yeah, I've never faced that question. You know, whether or not you make parole or not, of course, you got to put together your parole plan, and it's got to be approved by the parole board. And if they refuse you, I would imagine that they have to state their reasons. you know, you can't, I would think that it would be real difficult to go to the Montana Supreme Court. That's the only avenue I could think of, unless you went into federal court and had some allegations that your rights were violated in some way. But I think it's just a real tough road to hoe trying to overturn a parole board's decision. The best thing you can do, I think, is if you're in prison and they just flop you till discharge or whatever they do, they tell you no, you just got to keep working on putting together a better plan for your parole, getting some people and some support behind you, and work.
This is actually a violation situation. Someone that was out on parole and was violated and then had the hearing.
And he was found to have violated the terms and conditions of his parole at the hearing?
Yes. Yes.
Yeah, and like I say, it'd either be a federal district court or the Montana Supreme Court, as far as I know, but I'm just saying it'd be real tough to appeal it to some court, and your best avenue would be to try to put together another parole plan and mind your P's and Q's at the prison and carry on and keep trying. That's, you know, hiring a lawyer will help too. Getting people who support you, getting a job for when you get out, that's going to help too.
Thanks a lot.
All right, thank you. I'm going to call on line 2, so. Hello, you're on Dial Lawyer. Can I take your question?
Yeah, I have a question for John. That during this Richards murder trial, as I understand it, the taxpayers paid for these expert witnesses.
Mm-hmm.
And my question is, if somebody is on a criminal trial and they can just barely afford an attorney, they probably wouldn't bring expert witnesses in. But some of these trials you see, that people who can't afford the lawyers and have somebody appointed for them do bring in expert witnesses that are paid by the taxpayers. Do you think this is kind of an inequity?
Well, I think you asked that to me, but I don't do any criminal law, so I'm going to turn it over to Neil, who is more familiar with these facts.
What I would do, if someone came into my office and just had the money to hire me to do a criminal trial and to go to a jury trial, I would get a list of their assets, present it to the judge, and say, look, Your Honor, this is the money he's got, this is where it goes, this is what's coming in from his job, this is what he can afford. I might tell the judge, you know, just maybe, well, I might tell him how much I'm going to make from doing this service. And if there's no money left over, and say it's a murder trial or rape trial or serious trial, you know, it's going to take a serious trial to get some expert witnesses in there, aside from, say, a DUI trial where they get Phil Lively or maybe Lynn Kurtz from the crime lab. It's going to take some bucks. And what I would do is I would approach the judge and say, Judge, for this man to receive a fair trial, he's going to need an expert witness. And I want, say on one case I had, it was an elder abuse case, and I needed $1,000 to hire an architect, not an architect, but I guess it was an architect, yeah. And the judge gave me $500. I asked for $1,000, he gave me $500, so I got to go out and hire him. So, you know, the judges want to be fair. They're going to try to give you a fair trial, and if you raise that issue with them and work with them, I think that you'll get some funds. Did that answer your question?
Yeah, it did.
Okay, thanks.
Thank you.
Thank you. I guess also with the city elections coming up next week, that's one of the topics for municipal judges, that the defendant should pay more for the juries and for these kinds of witnesses that are coming out.
Yeah, and I mean, you know, it doesn't happen in municipal court. It's just a misdemeanor court, and the only expert witnesses generally you get in there are the people from the crime lab, and of course the state calls them, and sometimes I might too if it looks like it's going to be advantageous to my client. But one thing, you know, whoever gets to be judge, whether or not it's Don Loudon or Betty Wing, you know, what needs to always be remembered is that justice needs to fit the individual situation. I mean, you can't just go into court and say, all these people got to pay more for their fines and for their incarceration costs. So many people, and I do public defender work for the city of Missoula, so many people just have no money. And, you know, I think that Betty Wing, if she becomes a judge, that she's intelligent enough that she's going to be able to see this and to see these destitute people before her, and hopefully give them a break. Don Loudon's been really good at it, about that, and you know, there's been problems with the computer system over there that Don's had to face, and but when you look at it, you know, Missoula only brought in less fines as far as the city's court's concerned, only less than Billings. In other words, we were number 2 in the state. So Don Loudon's been doing a heck of a job in there. If Betty gets elected, she's going to have to, you know, sort of put aside her prosecution and her sort of tough hide as far as ignoring, you know, all the drudgery you see, and then the destitute people, because she's going to have to find hard, and I think she can do it. I think she can. I hope she can. And if Don wins, he's got the heart already. So we'll see what happens.
All right, we've got another call on line 1, so why don't we go ahead and take that. Hello, you're on Dial a Lawyer.
Hi. Actually, I've got a two-part question.
Okay.
Can you tell me the difference between a security deposit and a cleaning deposit, and then under what circumstances may either of them be withheld at a time that a tenant vacates property?
Well,
if anybody has a definitive answer to this, I'd like them to answer. I can tell you what I think it is, but every time I get to landlord-tenant, I open up the Montana Code annotated and read what it says. Does anybody have a definitive answer on that one?
Not without getting the code in front of me.
Well, that's what I have to do.
I always do it too.
Let me tell you what I think it is, and then I'm going to tell you to go either look up the statute, and it's in the revised codes. I believe there's section 72 something. It's Montana, I'm assuming this is residential?
Yes.
Montana Residential Landlord and Tenant Act. And you can find that at the public library or at the law library, or I believe even at the university library. My understanding is a security deposit can be withheld for only a certain number of things, like rent, which is unpaid, damages, and extra cleaning beyond ordinary, just ordinary wear and tear and so forth, or extra damages. For instance, if you leave your stove dirty or refrigerator dirty, that can be deducted from your security deposit. A cleaning, it depends what it is. There can be a cleaning charge that is not refundable, and you need to look at your rental agreement. The cleaning charges for things like shampooing the carpets between each tenant, or touch-up painting, or those kinds of things that relate to normal wear and tear and cleaning. So it can be a non-refundable charge, but if it's a deposit, it's just that, it's a deposit. So if you go in a deposit situation and clean the carpets yourself, touch up paint, fill in the nail holes and spackle and do all those things, you may be entitled to get that back. I believe if it is a deposit, it is subject to return if you comply with all the conditions of your agreement.
Well, in the case where it was clearly was a contractual agreement to ensure that adequate cleaning and maintenance of the property was done during the time of the occupancy, if the landlord fails to return that, can the recourse there be through the small claims court for the tenant?
Yes, that's exactly correct. Small claims court or justice court you can go to, and there's a certain time frame by which the landlord needs to give you a written statement of what he's deducting from your deposit. And I believe that is 30 days in Montana, although again, I'd have to look directly at the statute, but within that time he's got to itemize what he's charging you for and how much he's charging. If he fails to do that, not only can you go into small claims court, you can ask for damages such as attorney's fees. There are many provisions for what are called treble damages or triple damages in the Landlord-Tenant Act, and that applies to both landlords and tenants. So if a tenant wrongfully stays in the unit after the lease has been terminated, he can be subject to triple rents, and vice versa. If the landlord wrongfully withholds a security deposit, he can be subject to paying 3 times the amount of the deposit that was wrongfully withheld.
Thank you.
You're welcome.
Thank you. I know that the newest annotated versions just came out for Montana state laws. Are there any new laws out there that people should be aware of?
Lots of them.
I think the legislature outdoes itself in making new laws every year. I mean, it's hard for us lawyers to even keep up. In fact, you know, most lawyers don't know all the laws. You just sort of specialize.
Because I noticed Yvonne mentioned some new real estate
Well,
laws.
this wasn't something that was enacted by the Montana legislature, but one thing that has come up, and a lot of times we stumble upon these new things by accident. And I deal a lot in the family context, and the federal, the Congress has enacted some regulations concerning what's called a streamlined refinance. And what it does is it allows people who have a home loan with FHA, I believe it may apply to VA, Farmers Home, you have to check with your mortgage company or bank, but in any event, if someone has a mortgage written under these rates and you're at a higher rate of interest, without any charge to you or very minimal charge, you can go into your mortgage company and get that loan refinanced. Now, the benefit legally that this sort of side-off or spin-off side effect that I've found that's helped some of my clients recently, it's given us an opportunity to get divorced people who are no longer in that property, who've quit claimed their interest to the other party. We've been able to get them released from that mortgage. And that's something that's been a tremendous benefit, because generally that's something that takes about 6 months, may cost $500 to $700. With this streamlined refinance, it's a side benefit where the clients are able to get released from that mortgage. It will no longer show up on their credit report. It won't prohibit them from buying another house, and it's a very simple, streamlined process, and I believe that was by federal regulation or federal statute.
Oh, I learned something there now, too.
So imagine if somebody had any questions, they should call their attorney. And
either the attorney, or you can actually call your lender directly, and the lender, I believe, is required to do these. Some states will require a deposit equal to the cost of new title insurance, but I believe in Montana you don't even have that cost. And I found it very effective, not only in reducing the interest rate on the mortgage, but again, this side benefit of being able to get a divorced party released from liability.
it looks like we've got a call on line 1, so why don't we go ahead and... Hello, you're on Dial Lawyer.
Yes, I was wondering what kind of advice you would give to a student right out of law school, whether or not to join a firm right off the bat, or start off on his own, or go into the feds, or what kind of advice would you give?
Well, you know, if I might respond briefly, it all depends on what you want out of life. You know, I became a lawyer for a couple of reasons. One, I had a keen interest in people, I liked people, and I wanted to help people. Okay. Two, I was very poor at taking orders from anybody. And the nice thing about being a lawyer is that once you pass the bar exam, you can literally go out and hang your shingle anywhere you want. You know, eastern Montana is wide open, I think. We've got tons of lawyers here in Missoula. But you know, if I were you, but it just depends what you want. It's hard being out on your own. I came right out of law school, hung my shingle, got in part of the public defender program here in Missoula, and that's when it was still independent contractors. Something like if you want to be a trial lawyer, you want to get in the public defender program, you want to be a prosecutor. Either way, you're going to get a tremendous amount of trial experience, and you're going to be in front of the court almost every day. So if you want to be a trial lawyer, that's the sort of thing you want to do. But it just depends. You know, obviously, there's so many different ways you got to think about. One, where you want to live. Two, what kind of law you're going to practice, because you can't practice it all. Generally speaking, you know, I think maybe if as there's fewer and fewer lawyers around you, it's possible to sort of have a general practice. And I think John and Yvonne and myself sort of do have a general practice, but there's still areas we don't touch. And so you got to ask yourself, one, where do you want to live? And two, what kind of law do you want to practice? And then, you know, if you want to go in with a firm and be perhaps the little fish in the big firm, do that, become an associate, work your way up to partnership, and that's, at least you have people around you, too, who you can bounce ideas off. But you know what, even if you go out and hang your shingle, you know, there's always lawyers like that are around that's going to help you. So a lot of it's up to you.
There are lots of different models for how you get started. And it's important, I think, for you to think about where you want to be 10, 15 years from now, 20 years from now. What kind of a story do you want to have your career write? Think about those long-term goals that you've got, and then try to work backwards. It's hard to just go out and hang your shingle, and unless you can count on some financial resources that you bring to it on your own, and unless you really actively seek the counsel of other more experienced attorneys, because coming straight out of law school, you may not know the way to the courthouse door. It's an awful lot easier to go into a big firm, even if you want to be on your own at some point, to learn the trade, to finish off the process that has begun in law school. And just because you start out with a big firm, it doesn't mean that that's where you end up. One of the most famous lawyers in United States history, Clarence Darrow, started out his career, I believe it was representing corporate clients.
Railroad.
And the railroad, right. And he did that until he had developed some pretty doggone good skills, and then he decided that he wanted to do good with the rest of his life. Not that, not that representing a railroad is necessarily evil, no. But he had more idealism than that, and so he changed his practice. So that's another model that you can look at.
Okay, thanks.
Thank you. I know this last year they've actually talked about moving the law school from Missoula to Helena, I suppose, to be closer to the Supreme Court. How do you guys feel about that?
I would hate to see it as a practicing lawyer in Missoula. I mean, having the law school here is a wonderful resource for us, and that's purely selfish reasons. I also believe, though, that the law school is a part of the university system. It is not a totally separated, isolated entity. We have people at the law school who come from the philosophy department, who come from the business school. We have contacts, you know, there. I think it would be a mistake to move it. You know, I guess financially I'm all for finding ways to trim the budget. I think it would have to be a pretty major reduction in budget to really make it worthwhile to do that. I just don't think probably the savings would really result in a lot of benefit.
That makes sense. And one thing I'd like to sort of touch on is tax law. I was at a conference in Salt Lake City, and of course there's a number of people in Montana and around the western states who tend to do tax law themselves. How important is it for people to actually get a lawyer and to deal with those tax laws? I know that this gal had mentioned the fact that these people try to argue the law themselves, and they make precedents, which is often harder for future people that try to fight those same laws.
You're talking about tax court?
Tax court.
Mm-hmm. I don't think there's anybody in this group who practices in tax court. I think tax law is a very specialized field. There's actually a designation for a specialty in the law for a tax expert, and that's an LLM, and there are a few in Missoula, and I think if you have tax questions or you're going to be in tax court, you should seek out someone with that expertise. And that brings up something else when you said we are a panel of experts here. We're really not. We're a panel of attorneys. And in Montana, there is no designation for being an expert in family law or an expert in criminal law. Now, we may have all acted as expert witnesses in different cases or as an expert in a certain field, but I don't think we can call ourselves, really, we have no designation as attorneys as that, except for certain things like patent and copyright law. There are specific patent copyright attorneys, and there's a specific license for that. Same with the tax part of it. So I would seek out a tax attorney if I were going to be going before the IRS or before a federal judge on a tax question.
So if a person wanted a specific service or something that he's looking for, then probably the lawyer referral service in Helena might be could steer him in the right direction.
I believe so. Or I think almost any attorney could refer you to someone with expertise in the field of tax.
Or they may know somebody who knows somebody too. Oftentimes, that's how it works.
Well, I think our time's just about up, so I'd like to thank our panel here, John, Neil, and Yvonne. I'd like to thank everybody for calling in and watching the November or October edition of Dial Lawyer, and stay with us next month. I believe we'll have a show at the regular time, the 4th Wednesday of the month from 7 to 8. So I thank you very much for your calls, and thank you guys. It's been interesting.
Nice to meet you.
It's been fun.
about my presentation today, I thought about what possible group of people could get together who had a more focused, unified philosophy and sense of importance